So as such, latitude can be given. So talk to
Thank you, Your Honor. And sorry, Mr. Kennedy, that was the last question I had. I just want to ask it again. When you did have a chance to make contact with the foreperson, one of the things that she confirmed to you or said to you is that the paper she signed, affidavit she signed, and what was contained in it, and everything that she said to the media, she confirmed with you that that was all true, correct?
Yes, sir.
Okay. Excuse me?
Yes, sir.
Okay, thank you. No further questions.
any cross-examination? Question number two, please.
Go ahead, Mr. Khalid. Now, you were originally assigned to try and speak with Ms. Atkins on June 1st, 2026. Is that right?
Yes.
How did you initially make contact with her?
I attempted to call. I got her on the phone on June 1st. She said I explained to her the whole situation of me trying to set up an interview with her. She said she'll have to talk to her supervisor and call me back by the next day to confirm.
Clarifying questions. When you said you called her on the phone, what phone did you call her on?
I called the district court's bailiff office
So
phone
was
number.
this a personal phone or a business phone or what?
Work phone, I believe.
So you didn't call like her home phone number or cell phone?
No, sir.
And when you just said you were talking to her to set up an interview, was your assignment to actually interview her yourself, or was it to set up a time for her to sit down for an interview?
It was to set up a time we could interview. Yeah.
So on that week of June 1st through June 5th, you weren't actually trying to get a statement from Ms. Atkins, is that fair?
Yeah, no, sir.
And when you called her initially on June 1st, you were able to speak to somebody who identified themselves as Makalapua Atkins on the phone, is that right?
Yes, sir.
And during that call, she suggested Friday, June 5th as a date to potentially have that sit-down interview, is that right?
Yes, sir.
But she also stated that she wanted to talk to her supervisor beforehand.
Yes, sir.
And then she told you that she would call you back when she confirmed that she was ready. Is that right?
Yes, yeah.
Did she ever call you back?
No, no, sir.
Did you ever try to call her back?
I attempted to call twice.
And did you again try to continue to call the bailiff's office at the Honolulu District Court?
Yes.
So again, you're not going after her cell phone or her home phone or anything like that?
No, sir.
So when you weren't able to contact her by phone again, did you actually make contact with Ms. Atkins in person on June 5th?
Yes, sir.
Can you explain how that happened?
So I walked over to District Court. Our office is right across the street where I work. I went to go look for Miss Atkins or her supervisor, who was identified as Jerry through these phone calls. I was able to locate her supervisor, Jerry, and he escorted me to speak with Miss Atkins.
And where did you end up meeting with Ms. Atkins?
I believe it was on the third floor in the hall area by the elevators.
Was anybody else present as you met with Ms. Atkins at that time?
Yes, the supervisor, Jerry.
And again, the purpose of this meeting was not to actually interview her on that day, it was to set up a future interview, is that right?
Yes, sir.
Did you explain that that was the purpose to Ms. Atkins?
Yes, sir.
And she responded to you that she didn't want to talk to anybody from the prosecutor's office.
Yes, she didn't feel comfortable.
And she was visibly upset when you talked to her, right?
Yes, sir.
Her demeanor was...
Emotional, crying.
Ms. Atkins also, during that time, told you some things about her statements to the media, right?
Yes.
She told you that she didn't want to talk to the media, isn't that right?
Yes, sir.
She also told you that she was ordered by the judge to speak to the media. Is that correct?
Yes, sir.
She told you that she was ordered by the judge to speak to the media.
Yes, sir.
How many times did she say that?
She said it once, then I asked her again, and she repeated the same answer.
She also told you that she didn't want to be the foreperson, is that right?
Yes.
And she told you that people had been contacting her and her family on social media, is that right?
Yes, sir.
And that people had been showing up at her job.
Yes, sir.
She also told you that she met with the defense in this case, is that right?
Yes, sir.
And that they prepared an affidavit or a declaration for her, correct?
Yes, sir.
At that time,
Hang on, please, continue.
so at that time on June 5th, were you familiar with the declaration that she had signed?
I wasn't familiar with any details about that declaration.
So you hadn't actually read it yourself?
No, sir.
Now, on June 5th, did you also give Ms. Atkins a date to call you back if she changed her mind and did want to give an interview?
Yes, sir.
Did she ever call you back after that?
No, sir.
Thank you. No further questions. Oh, I'm sorry. I do have. Go ahead. I'm sorry. So initially, you completed. Sorry. After June 5th, did you prepare a report?
Yes, sir.
Okay. And that report was submitted on July 2nd. Is that right?
Yes, sir.
When did you draft that report?
July 5th. I mean, June 5th, correction. Yeah.
Okay. Were you on leave at any point in June?
Yes, I was.
Were you on island?
No, I mean, some part of June, but when I was on leave, I was off island.
Okay.
Yeah.
Approximately from when to when in June were you on leave?
It was, I believe it was June 15th. I left the island. Yeah.
And came back at the end of the month?
I came back at the end of the month.
Thank you for clarifying. No further questions.
Yeah.
Mr. Otake, read it right.
Sir, did you record the interaction you had with the foreperson?
No, sir.
And when you drafted your report, sounds like, what, several days later? Is that right?
I drafted it that day,
On June 2nd?
on June 5th.
On June 5th is when you drafted it?
Yes.
And so you summarized what was said, correct?
Yes, sir.
You did not have a recording of what was said, right?
No, sir.
One of the things you said is that at the outset, the foreperson told you she didn't feel comfortable talking with you, yes?
Yes, sir.
And then you continued to talk with her, yes?
She was continuing to talk with me, yes. Yeah.
No further questions.
Any other questions?
Just to follow up on that last little bit there, Mr. Kali'i-Puleole, these statements that the foreperson made about being ordered to speak to the media or not wanting to speak to the media, did you question her about these things?
She brought it up first, and then I questioned her again about it.
Thank you. No further questions.
Mr. Otake, any other questions?
No, thank you.
Mr. Kali'i-Puleole, thank you for being here.
Thank you, Your Honor.
Watch that first step.
Okay.
Mr. Otake, does the defense wish to present any other witnesses at this point in time?
Your Honor, I guess the first, issue or question is based off of what was testified to today, that the prosecutor, investigator confirmed with the foreperson that she confirmed to the prosecutor's office that everything in her affidavit was true and everything she said to the media was true. Based off of that, we would like to admit into evidence her affidavit and all of the exhibits attached to our motion. And the reason, as I discussed at the bench, I think is worth stating here on the record. This has been very uncomfortable for the foreperson, and we have tried our best to proceed in a way that is least uncomfortable for her. She just came here to try and serve. She didn't want to get involved in any of this. Unfortunately, things were said after that prompted us to have to look into this. That being said, we are trying our best to, protect her privacy, to not aggressively, go after her. We never tried to interview her while she was at work in front of her supervisor. We tried to be a little more discreet than that. And as you see, I've been referring to her as a foreperson. I didn't even say where she worked, anything like that. For that reason, as she indicated to the investigator, as you know, this case has generated, national attention, and I can tell you she's not the only one getting awful emails. Our firm has gotten countless awful emails because this was allowed to be broadcast nationally. Nevertheless, we're trying to do our job, but also be respectful of a juror. And that's why the issue isn't did she say these things. We know she did. She told the prosecutor's investigator that she did. It's recorded on the media, so we know she said that. The issue is, does 606 allow you to consider it, and if so, what is the impact of that? So I'd ask the court to accept these things into evidence, and a fatal flaw in the verdict, because it was not a unanimous verdict, and they did not follow the law the way it was given to them. We talk about how, at best, if you look at juror number 3 and what he says, at best, that's a non-existing offense of attempted reckless manslaughter from the Stanley case, right? I don't believe he had intent to kill, but maybe what he did had the capacity to. That's reckless manslaughter, and there is no such thing. And I guess I'd ask you to consider this. I mean, I know this isn't exactly what happened, but it's pretty close. Let's say a jury, and it's an important case. Obviously, he was facing life in prison, right? And let's say someone's facing life in prison, and a verdict comes back, and the juries find the defendant guilty of, let's say, murder. Let's say murder first, where he's going to be life without parole, the harshest sentence in our state. And then the foreperson walks out of this courtroom, and then there's cameras there, and the foreperson says, at her own volition and no prompting, well, you know what? Yeah, at the end of it, 6 of us thought he was guilty, 6 of us thought he was not guilty, that they didn't prove it, but we just returned a verdict of guilty. I have a hard time believing that our appellate courts would let that stand. I mean, I would have a hard time believing this court would let that stand. I mean, that would be absurd. And that's essentially what they're asking you to do. Maybe not to that extreme, but pretty close. Pretty close, when we know a juror has said they were not unanimous as to a required element, and she herself has said she didn't believe he was guilty of attempted murder. Meaning, at best, it was 11-1, which that's not what she was saying, but we can't just ignore this. We can't ignore this, and we have an opportunity to fix it. Just to address some of the prosecutor's arguments, we're not invading the power of the jury to act independently. I'm not sure what they mean by that, but we're not. That's the part, the independence of being able to think through things, consider evidence this way, give credibility, weight that way. Yeah, that's their independent right. What they don't have a right to do is not follow the law. That's different than invading their power to act independently. We're not invading jury secrecy. They came out and she said what she said. When you allowed us to talk to her, she said what she said. We never did, nor will we ask her. We didn't ask her, why did you, how did you end up over there? We're not invading their secrecy. We're not invading their freedom to deliberate. We're not harassing any juror. All of these statements were made freely at their own will. So, that was the gist of a lot of their opposition, is these policy reasons behind this. We're not violating that. And then again, it's a balance. Yeah, we don't want to inconvenience any juror, make any juror feel uncomfortable, but we also want to get it right and make sure that there was not an illegal verdict under the Constitution. For these reasons alone, a new trial must be granted. The text messaging, and again, we objected to this being broadcast nationally, but it was allowed. And, then a commenter on one of these live streams commented during deliberations, before the verdict was returned, I've been texting with one of the jurors and they're going for count 3 attempted manslaughter. And there's a couple of significant things about that. It says, I've been texting with, which infers a conversation, multiple texts. I've been texting with one of the jurors. It infers an ongoing conversation. The use of the term count 3, they're going for count 3 attempted manslaughter. No one in this courtroom ever referred to anything as a count. Nobody said the lessers is count 2, count 3. Nobody said that. We pointed out how in the statements to the media, one of the jurors did use the term, we went through all of the counts. So one of the jurors in the deliberation room, apparently the term counts was being used, even though we didn't use it in this courtroom. And now this person is using the same term, they're settling in on count 3. What else do we know about that? On the verdict form, although it was not indicated as counts, the third option, which would be, if you wanted to consider them counts, count 3, was extreme mental emotional distress, disturbance, manslaughter. So he said, and presumably, I don't even know I don't think the verdict form was even publicly accessible at that time. So some guy, wherever he was, and somewhere on the mainland, would have never known that count 3 was extreme mental emotional disturbance, or at least the third option in the verdict form. But he used that term. He didn't just say they're going for attempted manslaughter. He said they're going for count 3 attempted manslaughter, using the same reference to count as a juror did to the media, and picking the number on the verdict form that was emailed. And then lastly, that he correctly predicted the verdict. I mean, that, and there's case law we cited about the import of when somebody correctly predicts something, you know, how it provides an indicia of reliability. So there is indicia of reliability to lead to concern because of that. And I don't believe it is something where we can say, maybe it was just this or maybe it was just that. Remmer versus United States, the United States Supreme Court case. Private communications with jurors during trial concerning matters before the jury are presumptively prejudicial. Presumptively prejudicial. And the burden rests heavily upon the government to establish harmlessness. That's our United States Supreme Court. Our Supreme Court, 76 Hawaii 172, State versus Foreperson. Once a defendant makes a prima facie showing that an improper influence may have affected the jury, prejudice is presumed. Prejudice is presumed. And the state must establish beyond a reasonable doubt that this misconduct did not affect the defendant's substantial rights. From what we've submitted and the arguments we've made and the inference and the indicia of reliability related to count 3, accurately predicting it, the timing of it all, we've made a prima facie showing. The burden shifts to the state to establish beyond a reasonable doubt that it did not happen or did not affect his substantial rights. What did the state do to meet this burden? Nothing. Nothing. It doesn't appear they went and, you just saw they have investigators that work for them full time. Probably many of them. And that's why we put the burden on the government, because they're the ones with the resources. They're law enforcement officers with the right to subpoena things, to get search warrants, to interview witnesses. You know, if they believe there was tampering with a juror, that could be a crime. They could, call people to the grand jury. There's any number of things they can do to meet this heavy burden of trying to show beyond a reasonable doubt that my client's rights were not affected. They did none of that. Call your investigator. Tell us what you did to figure this out, because I would assume you'd want to figure this out. I'd assume you'd want to know, in your role of seeking justice, not just convictions, did this happen? This is concerning. We should look into this. It's not only our burden, but it's our ethical duty to, if there was misconduct here, we want to know. What did they do? Nothing. I don't think they wanted to know. I think they were afraid of what they would have learned. So prima facie showing has been made, and they have done nothing to meet their burden to establish beyond a reasonable doubt that this misconduct did not affect my client's rights. Prejudice is presumed. We don't need to show harm. Prejudice is presumed. State versus Furatani. Remner versus United States. Presumptively prejudicial. I come back to what I said earlier, Your Honor. This motion raises important questions about what you are okay with in your courtroom. And I mean that respectfully. Do the jurors have to follow the instructions? The jury instructions, I'm not going to go through all of them, but many of them directly call into question what happened here. You are the judge. This is number 2, page 2, from the instructions. You are the judges of the facts of this case. You will decide the facts, what facts were proved by the evidence. However, you must follow these instructions even if you disagree with them. They're told they have to follow the way the law works. Page 16 of the instructions. A person is not guilty of an offense unless the state proves beyond a reasonable doubt that the person acted with the required state of mind, as these instructions specify with respect to each element of the offense. That's the law. They took an oath to uphold that. We now know that that was not a unanimous finding as to the requisite state of mind. We talked about the elements on page 19 and what was required before they could unanimously find guilt on the attempted murder. We talked about how one juror said she didn't believe he was guilty of attempted murder. And then lastly, as to the text messaging issue, one of the last instructions that is given to them on page 43, during your recess from deliberations when you are released to go home in the evening, you must not discuss this case with anyone or permit anyone to discuss this case with you. You must not read or listen to news accounts about this case if there are any. You must not discuss this case with any person other than your fellow jurors. You must not reveal to the court or any other person how the jury stands, numerically or otherwise, until you have reached a unanimous verdict and has been received by the court. It's one of the last instructions you gave them, which raises the question, do jurors need to follow the law in your courtroom? Of course they do. Of course you're not okay with that. It would be an incredible coincidence if somebody, prior to the verdict, used the term count when nobody in this trial used it, and then the jurors used it, that they would know it was the third option on the verdict form, and that they would know and accurately predict the verdict. It would be an incredible coincidence. And we can't, there's too much at stake to just assume that it was some lucky guess. We have established a prima facie showing. There's presumptive prejudice. They could have done any number of things to try and meet the burden to show that it didn't happen. In closing, Your Honor, I'll say this.
Big issue here is, of course, what started all of this is the statements to the media by two of the jurors. In those statements, the jurors are asked to explain how they reached their verdict in this case. There could not be a more heavy indication that what they're talking about is their mental process in coming to their verdict. Now, one of the exhibits was cut off for the question. The second exhibit, involving the foreperson, she was directly asked, how did you get to manslaughter, or why manslaughter? And that's when she started to explain. So these statements are directly the jurors sharing their mental processes. This is not an objective misconduct. This is not anything other than clearly violating Rule 606B. And I don't know how to put it more clearly than what's actually in front of the court. I do want to point out that defense, in their reply memorandum, also stated that their motion is predicated on this inadmissible evidence. Dr. Konig relies only on the portion of their statements that identified the jury's determination underlying the verdict. It's on page 7. The statements underlying the verdict, the reasons for how they got to the verdict. That's what we're talking about here. All of this comes from those statements. Taking a minute to talk about the application of 606B. I did do a application of 606B in my memorandum, and I did indicate which proffered evidence that would potentially, or that the court could consider under 606B. I want to be clear, though, when I say that statements 3 and 4 can be considered by the court. Statement number 4 is all in the past tense, despite being misstated as a present sense statement by the juror, by the foreperson. We don't know when the foreperson believed or didn't believe this based on the affidavit that the defense prepared for her. It's completely unclear. So I don't have enough information to tell you whether this violates 606B or not, because I don't know if this is in deliberations, if it's sometime before deliberations, if it's a statement for a state of mind she had after deliberations. The information is just not contained in this statement. If the statement is applied as her mental state during deliberations, then it would be inadmissible. But I can't. Then it would be inadmissible.
Okay.
But I can't say that because I can't assign anything further than what is actually written on the paper. And the foreperson is not here to testify as well. Not here to face cross-examination about the circumstances of this. Not here to face cross-examination about who prepared this for her, whether she understood it, whether she had legal representation, what statements were made to her in the process of signing this. All these questions have been unanswered by the defense failing to present this witness, and more. So when I say that the court can consider this, yes, you can. It just has no relevance to the court's determination because there's no time assigned to it. With regards to statement number 3, the jury did not unanimously believe that Dr. Konig had an intent to kill his wife. Again, there's no time. There's no time element to what this statement is. And there's also the issue of polling. The purpose of polling is to let jurors who have lingering doubts, that have a doubt later on or that have second thoughts. The purpose of the polling is to let them voice those. It's kind of a speak now or forever hold your peace kind of moment. And that happened in this case. And every juror said they agreed with the verdict as it was read. So, yes, you can consider statement number 3. It just doesn't have any effect because the jurors were polled under oath when they swore that oath to return a verdict according to the law and the evidence. They were polled. They all said they agreed. Overall, what we're asking here, Your Honor, is not to deny this motion on a technicality. And that's the reason that I spent so much of my opposition going through the history of jury trials, the history of jury deliberation, jury secrecy, the history of all this stuff, because it's fundamental to the jury trial system that the jurors don't have their internal deliberative processes examined, brought up, testified to, cross-examined on. All of those things stymie the entire purpose of jury trials. Well, the court sounds somewhat reluctant to consider the effects. There is a chilling effect on future trials if we start opening those doors. There's a massive chilling effect. Any juror in a case against somebody who's potentially very popular publicly, a sports figure, something like that, any juror would be pressured knowing that their verdict could be attacked, that their thought process in reaching their verdict is not secret. It's essentially what we're asking, what you're being asked to do is to break the promise the judiciary made to these jurors. We bring these people in. We ask them to serve, to sit for a month, and they're told that their deliberations are secret. And it is an incredibly, essentially, if you do not believe in secrecy of deliberations, you do not believe in jury trials. As simple as that. Moving on, getting closer to the end here, Judge, to the YouTube comment. It's an anonymous YouTube comment. The defense is citing the U.S. Supreme Court case, I believe Renner. In Renner, the contact between the outside person and the juror was known. The juror reported it to the court. There was an FBI investigation in that case. There's an FBI report prepared. It's clearly distinguishable from this case where there is no confirmation of juror contact. The specter has been raised, yes, but it is defense's burden to actually make that prima facie case, and they haven't. So we're citing a case with a completely different set of facts and trying to apply it to the same way. And that's not what we have. What we have is an anonymous internet comment. Anytime there's a high publicity case, anytime there's a case that is on the internet, which there are certainly going to be more to come in the future of any jurisdiction. Anytime somebody makes a comment claiming to have inside knowledge or claiming to know something else, anytime that happens, what defense is saying is that should be an automatic granting of a new trial. And that's not true. Consider the actual context of this statement on its face. There's no statement indicating that there was communication, anything other than potentially somebody leaked the verdict. There's no indication of any talk about discussing with the juror how they thought about things, convincing the juror to vote one way or the other. There's none of that. So for that reason as well, there's no prima facie case. So overall, what defense is asking you to do is to get into the juror's mindset of how they ended up at the verdict they ended up. Fortunately, factually, it is. That's how these statements came about. That's how these things were raised. And that's where we're at. And that's why 606B applies. These statements are inadmissible, and the court should deny this.
She's talking about when she says, the jury did not unanimously believe that Dr. Konig had an intent to kill his wife. Do we really think she was talking about when deliberations started and not at the end? I mean, I did not believe that he had an intent to kill his wife during the incident, and I believed that he was not guilty of attempted murder. Do we really believe that she's talking about something other than what we know she's talking about, which is during the deliberations? So, I mean, that argument should not carry much weight. Again, this thing that somehow getting this right and enforcing his constitutional rights to a unanimous jury verdict is going to have a chilling effect on jurors in the future. I don't see how that would be the case. So, one second, Your Honor. And again, I hope the court, I'm sure the court understands this. I don't know how to be more clear about it. I'm not asking you to get into the why they reached this decision, right? When the foreperson says, I did not believe he had an intent to kill, I do not believe he was not guilty. I'm not asking you to consider why she felt that way. Her deliberative process in getting to that conclusion. I'm not asking you to consider that. That's what 606 says we cannot. They wouldn't use the word processes or process if we couldn't consider the result. We poll jurors as to the result. So obviously we're allowed to ask them about the result and consider it. What would you, Your Honor, think of it this way. Think of it this way. If you polled the jury and 6 said, no, I don't think he was guilty during the poll, what would you do? You would send them back to deliberate. You wouldn't be like, okay, well, we're not going to get into your mental deliberative processes and your result, and we're going to, that's the secrecy of your deliberations, but we'll take the verdict and lock this guy up for the rest of his life. Of course not. So obviously the polling process demonstrates you can look at the objective end result and consider it. And I ask you to think about that. Those two examples. If you did a poll and it was not unanimous, what would you do? And if there was a verdict and a juror walked out and said to the camera, well, we found him guilty, but 6 of us really at the end thought he was not guilty, but whatever, I have a hard time believing that Your Honor or our appellate courts would just say, hey, secrecy, we don't want to, we don't want to, that's up to them. No, it's not up to them. It's not up to them as to whether they follow the law or not. And so again, we're asking you to get this correct now. There is enough here to rule that way without doing inquiry or whatever. They could have done that. They have investigators. If they really wanted to do that and meet their burden, they could have gone out and talked to every single juror. They didn't. And so we're asking that you grant the motion today and set the case for our second trial.
Jurors can be examined on the existence of outside influence. This is brought up by the defense in the Remmer decision. And Remmer is treated, examined, and used by the Hawaii Supreme Court on this issue. Assuming the prima facie case for outside communication has been made, right, the Supreme Court of Hawaii directs the trial court by saying where the existence of an outside influence, such as juror misconduct, is brought to the attention of the trial court, the court must ascertain the extent of the influence, and then in its sound discretion, take appropriate measures to assure a fair trial. This is State versus Chin, 135 Hawaii, 437, page 439. It's a 2015 case, and it cites Remmer versus United States in its reasoning. And it goes on to say that the outside influence need not touch directly on the guilt or innocence of the defendant to trigger the presumption of prejudice. It is enough that during the crucial period of jury deliberations, there was a private communication bearing even remotely on the trial or the jury's function in it. And I understand the argument as to who bears the burden and who needs to counter it, but here what the Supreme Court is telling this court, that the court must ascertain the extent of the influence. So the burden is on me, right? And as abhorrent as this sounds, the way I read this case is telling me that I have to do what I really don't want to do and bring in these jurors and ask whether or not they were tainted by outside influence. And as much as I don't want to do that, the case law is must. The court must ascertain the extent. So, counsel, as much as you might want to rule in today, I think I have to do that. Does anybody object, or do you think I'm misreading the case?
Well, our position, Your Honor, is there is enough here to grant the motion. If there's enough here to grant the motion without that inquiry, because we made a prima facie showing, and the state has not met its burden to overcome the presumptive prejudice. So there's enough here. It's not for Your Honor to go through this exercise to try and save the state's, the verdict. And I mean that respectfully. So here's what I mean. I would. There's enough here to grant it. There's enough here to grant it. If you were, you can grant it without further inquiry. I don't think you can deny it without further inquiry, but you can grant it without further inquiry. And here's the problem why it should be granted without further inquiry. Here's why it should be. We're here on, what is today, August 14th? This motion was filed on May 15th. Okay, the trial ended, I think, in April, right? So May, June, July. Well, here we are over 4 months later.
So let me pose the question slightly differently. What if I disagree with defendant's interpretation of 606B and the mental processes of the jury?
Then you would still grant it as to the texting issue, following the cases that we cited.
Well, Chin requires me, right, to ascertain the extent of influence, because just because there's contact doesn't mean that it's a bad verdict.
Well, I would disagree. That goes against the cases that we cited that suggest that any outside contact is presumptively prejudicial. So we can't ignore that. We can't ignore that. So we're not starting on even footing here. We're starting on the presumption that it's prejudicial. And that's, again, State versus Furutani, 76 Hawaii 172. And the point, again, we would be ignoring that And what do we do with the fact that the state has not met that burden and done anything?
Well, let's step back. If we take for face value Exhibit D, there's contact, but we don't know if there's influence, right? And
There was communication. And that's what the cases talk about. Communication with jurors are presumptively prejudicial. It doesn't say influence with jurors are presumptively prejudicial. And you cited, thankfully, some other cases that suggest that. We don't, it's not a harmless, hey, what'd you guys eat for lunch in the verdict room? It's presumptive, the contact, the communication itself is presumptively prejudicial.
influence, and there's a section of the opinion that talks about the court's duty to investigate. And the very first part of that section is when there is juror misconduct that presents a potential for substantial prejudice to a defendant's right to a fair trial, there is the rebuttable presumption of prejudice, which is what you're talking about, Mr. Otake. And the trial judge is then duty bound to further investigate the totality of circumstances surrounding the outside influence to determine its impact on juror impartiality. Again, as much as I dislike it, I think I'm handcuffed as to what this particular case requires me to do. This is a Supreme Court case. It is good law, and it is binding upon me. So as much as we all object, I think this is what's required, at least of this court. The court will contact the trial jurors in this case, have them come in, and the questioning will be conducted by the court as to, one, whether or not there was outside communication during jury deliberation. If the answer is yes, I need to probe further to ascertain the totality of circumstances of the conduct so we can determine whether or not it affected the defendant's right to an impartial opinion in this case. And I understand this is the objection of both of the parties, but I think this is what is required of the court, unfortunately. So the court will make that attempt to get these jurors back. These are fucking belong.
And again, I mean this respectfully, if that was the case, we shouldn't have set this motion 3 months after it was filed, because now this case has been heavily publicized. The jurors were told that their prohibition on reading the news or looking into it ended, and you know, who knows what day. I mean, some of them might be watching this Zoom right now. You know, I mean, I wouldn't doubt it, right? So, you know, I understand what your focus on the Chin case. You know, again, there's the Furutani case that talks about, can be, you know, this the state's burden. So we do object to that process just from the standpoint of the delay, the exposure, and the reality of calling jurors in here in a public setting, you know, 4 or 5 months after their verdict to now interrogate them about potential misconduct. And I think there's some legal, you know, issues about that. You know, I mean, should they have counsel? Should they, you know, I mean, do they have immunity from things like that? You know, I just placed that all on the record, but I understand the court's ruling. Whatever the court does, we ask that we expedite it. You know, like when this motion was filed 3 months ago, Dr. Konig is sitting in jail. You know, if this motion is eventually denied, we want to quickly go to sentencing. We want to appeal quickly, and we want to get back to a second trial as soon as possible because he's sitting in jail with no bail. And so, whatever the court decides to do, we just ask that we do it as quickly as possible.
I'm talking later on in the week, the Friday. Can we do that?
The 11th?
The 11th.
We should be done by then, Your Honor.
Yeah, that's why I'm suggesting the end of the week.
That's fine with me.
Yeah.
Okay. So let's do that. Schedule further hearing, September 11th. Council 9:30 in the morning. Appreciate your indulgence. Anything else you want to take up on the record this morning?
Yes, I would ask for the opportunity to provide briefing on the process or parameters of questioning the jurors, including potentially a request to do it under seal or in camera. And if we can possibly have the opportunity to provide that briefing.
What deadline are you looking for, Mr. Otake?
Well, I would
In case you
say
don't want to respond.
maybe by August 28th or 21st, 1 week.
Yes, would appreciate that. Can the state respond by the 28th?
Yes, Your Honor.
Okay.
And just so I guess we have the same place to start, is the court's current intention is the court will be the only party examining the jurors.
Right, and it's on the contact.
Well, and that would be what our briefing would be about. And then just the last thing I'll add, Your Honor, I mean, you know, I understand, not to relitigate it, but the Chin case, I believe what it was standing for is you cannot deny the motion without further inquiry. But I do believe it allows you to grant it without it. So, and I think that would be an appropriate way to read Chin in conjunction with Furitani. If you're going to deny it, you know, you need to do further inquiry. But I don't believe Chin says you can't grant it. And I think that's actually what happened in that case, is he denied the motion, and then the Supreme Court said, well, if you're going to deny it, you got to at least do some inquiry. So if you change your mind and want to grant it, we can avoid questioning the jurors, because I think it allows that to happen without questioning them. But we do appreciate the opportunity to provide additional briefing on the process, and you know, I think we should think long and hard about, you know, how we do that and whether it should be in camera or what. I mean, there's a lot of issues there, and you know, also, you know, what is told to the jury about it. And I think there should be additional questions about whether they watched this hearing today, and whether they read the motions, or what they've seen since the trial. I mean, this is just a can of worms, but you know, we'll do our best to address that in the briefing.
Thank you. Mr. Bonner, anything else you want to add?
Nothing further from me.
I guess the last thing is, I mean, so I guess you're just going to reserve ruling on everything until after.
All of you brought up some very good points in addition to what was already agreed. I think we should get the full record, and then the court will make its final decision.
Understood. Thank you for your time this morning.
Likewise, counsel, thank you. Thank you for the hard work.